supervising attorney at Community Legal Services, and I'm joined by Rhiannon DiClemente, who's also an attorney in the employment unit at Community Legal Services. And like I said, we're going to try to talk about a lot of stuff here today. So we're pretty much breaking this down into two general sections, and there's going to be some overlap, as you'll see, between them. Rhiannon, can you go to the next slide? So the two general realms of issues that we're talking about are for people who are out of work, right, who have already stopped working, lost their job, business where they were working shut down because of COVID, and then for people who are still working. So we're going to start with the area for people who are out of work, which unfortunately is probably most people at this point. It's definitely most of our clients, at least. So there's several different issues that may come up. Obviously, the big one is unemployment compensation, and also a new program called Pandemic Unemployment Assistance, PUA. You all may have heard about some of the stimulus, the CARES Act and the stimulus packages that were put out by Congress. Unfortunately, they used a ton of acronyms that all sound the same. But at least for now, we're going to talk a lot about unemployment compensation, UC, and pandemic unemployment assistance, PUA. And then also making sure that workers have been paid for all of the hours that they worked before they were out of work, before they lost their job. If they have not used, if they have accrued but unused sick time, they should also be paid out for that under Philadelphia law. We'll talk about that. Some other federal relief under the CARES Act and the stimulus package, and then healthcare benefits. All right, so starting with unemployment compensation, let me just say first that Rhiannon and I, while we know a good amount about unemployment compensation, we are not the complete experts. Philadelphia Legal Assistance, our sister organization, especially Julia Simon Michelle over there, probably knows more about this stuff than anybody in the state, maybe even more than the Department of Labor themselves. And there's a million different examples and like weird cases where things might apply in different ways, but we will try to do our best to answer any questions you have about applying stuff to specific facts. Just to give a general overview to start. So basic unemployment compensation, right? The program that has existed before COVID provides 26 weeks of benefits. You have the weekly benefit rate there. So the minimum of $68, maximum of $561. This program applied right before COVID, but it can cover a lot of people who have lost their jobs because of COVID. And then there's a couple things with regard to unemployment compensation specifically, again, not talking about PUA yet, that the federal legislation did. So one is it added $600 a week for anybody who is receiving unemployment compensation beginning April 5th, I believe, and going through the end of July, which is a huge deal. That's a lot of money for people. So even if they're only getting that minimum $68 a week, because maybe that's all, they didn't have that much income beforehand, they're still going to get that $600 a week on top of that. And there's nothing extra that they have to do to get that. It just comes automatically. They actually stagger the payments. So one week you get your regular weekly benefit rate, and the next week you get your $600. The other thing it did, as I said before, that you get 26 weeks of eligibility. The federal legislation extended that by 13 weeks. So now basically if people are to apply today or have applied recently, they should be eligible for 39 weeks of benefits. One thing to keep an eye out for is that some people may have applied in March, right when everything shut down because of COVID. They may have been found financially ineligible. There's a crazy, complicated way that unemployment compensation calculates your financial eligibility, looking back at basically 4 of the last 5 quarters. It's this whole convoluted thing. But so if people applied in March and they may have been found ineligible, there's a chance that if they apply then after April 1st, when we're in a new quarter, it changes the period that you're looking at for financial eligibility. So basically, if anybody applied after April, we're looking only at all of 2019. So what did they earn in all of 2019? So there's a chance that if they applied before April 1st and were denied, but then reapply after April 1st, they may be eligible now. Just something to keep an eye out for. All right. So the way that this works, right, is you apply, you hopefully are found eligible. Everything is kind of done through the mail after that point. You can apply online, but after you do that, you'll get something in the mail, usually a PIN number. So you should get your PIN number within a couple weeks. Everything has been really, really delayed, and that's been another problem for people. But you should be able to do that, and then you'll be paid either via direct deposit or debit card. Just keep in mind that everything is really stressed. They've gotten, I think, over 1.7 million claims since COVID went into effect, when they were averaging something in the like tens of thousands per month before that. So everything is kind of a complete crapshoot right now with what's happening, but there are ways that you can get help. So one, just starting with how to apply. The best way to apply is online at uc.pa.gov. With a computer, I think they're getting better with the mobile stuff, but it's still best to do it on a computer. They only have that application available in Spanish and English, so it's a real problem for people who do not speak those languages, obviously. But luckily, PLA, again, our sister organization, has created a hotline that's actually available statewide. So for anybody in the state can call for help submitting an initial application. So mainly for people who do not have internet access or aren't good with computers, but especially for people who don't speak English or Spanish, although they also help Spanish speakers. So that number is up on the screen there, 215-999-6910. One thing to keep in mind is right now that's only for unemployment compensation applications, not for PUA applications. They're trying to expand to be able to cover that, but right now it's just for people who want to apply for unemployment compensation. And again, we'll explain what PUA is in a second. So again, I talked about the delay in PINs. Basically, you can't file your biweekly claims to claim your benefits that you have to actually file for every 2 weeks after the initial application. You can't do that without a PIN number. That's delaying a lot of people, but they are allowing people to file back to the date, basically, that they should have received their PIN number. So don't panic if your clients are saying, hey, I still haven't gotten a PIN number, I can't file my biweekly claim, what do I do? Hopefully for now, we're mostly saying, sit tight, wait till you get your PIN number, and then you can file going back a few weeks, right? So that's all assuming you're found eligible, basically, and most people who are laid off or out of work because of COVID, it's not very complicated and they should be found eligible. If they are denied, they have a right to an appeal. And they should do that within 15 days. So the best way to do that is to contact Philadelphia Legal Assistance. Again, they help people. The main thing they were doing before all of this is helping people appeal unemployment compensation denials. So there is legal help for that. That's free. And then when you're going through the initial application, one way to make sure that people aren't denied is to choose the right the reason for separation. So Rhiannon just put a very helpful chart on the screen that I reference a lot. So this has several different reasons related to COVID or different scenarios, and then explains what you should say on your application for the reason that you're out of work. So the cleanest way and the way that people most often are approved very easily is through lack of work or laid off. So if you can say that, if one of those reasons on the left-hand side of this chart apply to you, or potentially other ones, that's always best to choose that. Don't just choose that if it's not true, because that might cause problems, right? And then if you're denied, it makes it harder to appeal because you were probably properly denied. But I can't remember if we talk about this later, but there are other ways that if you're not just out of work because your business is shut down or you were laid off, there's ways that you should be able to get unemployment compensation. Rhiannon, can you remind me, do we go into that when you're trying to talk about what to say to employers later, or should I cover that now?
You can cover it now.
Okay. So one issue that's been coming up a lot for us, right, are for people who don't feel safe working, right? And this is going to be more of a problem as more businesses open and people still don't feel safe going back to work. But even for people who are working in, there might be a restaurant or something that's doing takeout, potentially for people who are working in hospitals, right, who are deemed essential workers but don't feel safe. Maybe they have an underlying health condition. is can they get unemployment compensation if they quit or if they refuse to work and then are fired? So one thing that's really, really important, and the answer should be yes, if they have like an underlying health condition that puts them more at risk for COVID, they should be able to get unemployment compensation benefits. But they want to take a few steps to make sure that that works. So what we always recommend is talking to your employer about your concerns before quitting, preferably in writing, and saving a copy of whatever you do so that you can, have that as evidence for if you are challenged in your unemployment compensation claim. But basically, complain to your employer about the working conditions, what it is that you think is dangerous. Let them know that you have a health condition that puts you more at risk. If they say, okay, you can work from home, then you probably don't have a good reason to quit anymore, right? But if they refuse to do anything and don't change anything and say, no, you still have to come to work, you can quit potentially and still get unemployment compensation, or you can say, no, I'm not coming to work. And if you're fired, you can still get unemployment compensation. But if you don't raise those concerns first, it's much less likely that you're going to be eligible for unemployment compensation. Similar things with issues with childcare. Just make sure that you raise these issues with your employer before you quit because, for example, you have to take care of your kids whose school has closed. And we'll talk, this kind of similar issues come up in other areas when talking about workplace safety, but the main advice kind of goes across all of those areas, which is convenient at least. So it both can protect you against retaliation and also set you up for an unemployment compensation claim.
So I'm going to talk a little bit now about pandemic unemployment assistance, which Seth mentioned. So this is a special temporary program that was created under the Federal CARES Act. It's available for folks who aren't going to be eligible for regular unemployment. So who is this? It's going to be our independent contractors, gig workers, people who are self-employed, like small business owners, but also people who are not financially eligible for regular unemployment. So they didn't have enough past earnings, they weren't working as much in the last year, and also people who maybe weren't working at all. So if someone had a job offer and that was rescinded due to COVID, or they just didn't start because of COVID, while those people wouldn't traditionally be eligible for regular unemployment, they are eligible for this new pandemic unemployment assistance or PUA program. Again, this has to be tied to reasons related to COVID-19. So if you lost your job, you lost business or revenues, or your hours are reduced because of COVID-19, then you're likely going to be eligible for PUA. Similarly to regular UC benefits, this is also 26 weeks of weekly benefits, and they're going to range from a minimum of $195 a week up to $572. So for people who are eligible for PUA, they're also going to be eligible for that extra $600 a week, like regular unemployment. And again, that's going to run just through the end of July. That's just a temporary benefit that was part of kind of this federal assistance program. So again, this can be a really big benefit for people who are out of work right now because of COVID. And it really does expand benefits to a whole range of people who wouldn't otherwise be eligible under our existing unemployment compensation system. If people go through these 26 weeks of benefits and they're still out of work due to COVID, this program also has the 13-week extension like regular unemployment compensation. One thing to note, we see a lot of people come in who are cash workers. A lot of times people who have unreported cash earnings have a lot of trouble getting unemployment compensation because their employer hasn't been paying into the system because there are no reported wages. People who are cash workers might be eligible for PUA, but there is just some concern there if they didn't file taxes on that income. So that's just a risk that we like to raise for people who are cash workers and thinking about applying for PUA. If you guys run into any clients with this issue, you can definitely refer them to us or PLA for assistance with kind of thinking these things through. Just see. Okay, so unlike regular unemployment compensation, people who apply for PUA, you're not going to get a PIN number. You'll just rather have a username and a password. And for PUA, you file weekly certifications through the PUA dashboard. So it's a little bit different in terms of reporting any wages than the regular UC system. So yeah, I'm just going to go to the next slide now. So the PUA application, it's available online on the Unemployment Comp website. It's a separate application from regular UC. So if someone just goes to the main landing page, you'll see there's a little dashboard. It says file for PUA. They'll want to go through that, not the regular UC system. It does ask users to upload documentation showing proof of employment and earnings. So this here is just a list of some documentation that might be helpful if you're helping folks kind of through this application or someone has questions about it. You don't have to have documentation for earnings, but I'll just pull that up there. So you can always fill out the application first and upload documents later. If you don't have documents showing earnings, you will essentially get the minimum weekly benefit, which is $195. But you know, if you have documentation of earnings showing more, you'll want to try and upload those so you could get more. And then again, if you get PUA, you get that extra $600 a week through the end of July. So some contested issues that may come up when people are applying for regular unemployment or PUA. Oh, sorry, I skipped ahead on my slides here. For PUA, it can be backdated to the end of January of this year for if the loss of work was related to COVID-19. For most people, you know, it's going to make sense to backdate it probably to, I think it was March 16th, maybe, that the governor's shutdown order went into effect and when most people really started to see a reduction in work. Like I mentioned, PUA is a temporary program, so it ends December 31st of this year. One thing to note is that for people who are still working, you might still be eligible for benefits, regular UC or PUA, if your hours have been reduced. So some people might think that just because they're still working, they're not eligible at all. That's not the case in Pennsylvania. If you've seen a reduction in hours, you might be able to kind of make up the difference with partial UC or partial PUA. And even if you're getting partial benefits, again, you're still going to be eligible for that extra $600 a week through the end of July, which can really be helpful for people right now. One thing to note about PUA is you cannot receive PUA benefits if you're getting paid leave. I don't expect that this will come up that often because most of the time people who are gig workers or self-employed aren't going to be getting paid leave. But that's just one thing to note. For people who are getting regular unemployment compensation, if they're getting some sort of paid leave or benefit, that would just be something that you would report on your bi-weekly certifications, and it would draw down on the amount of benefits that you're receiving. Like I mentioned, you can apply online. It's a separate application for PUA. It's a whole new system. So they just set this up. We've been seeing a lot of issues with the application. You know, people answering certain questions and getting kicked off, things like that. We are actively working with the state government to try and work through some of these glitches, but just want people to be aware that the system's not perfect, that they're still improving it, and it can take a while to, I think, you know, we were hearing up to 3 hours for some people to complete the application. So you just want to go into this with a lot of patience. And like I mentioned, documents, uploading them can be difficult for some people if you're not, you know, very tech savvy, especially. But this again can be done later. And if you don't upload the documentation, it's likely that you'll be assessed the minimum benefit. So what contested issues might come up when you're applying for unemployment? One of these issues that Seth kind of alluded to was employers saying that the reason for separation was due to some sort of good cause termination or voluntary quit instead of a layoff. So that's when it is really important, if you are unable to work due to some sort of health or safety issue, to really try and address that with your employer and get documentation or email correspondence or something about it. In the case that the employer might contest the reason for separation, so you have some sort of proof as to what happened. For gig workers, especially for PUA, there's some special rules. So gig workers, like I mentioned, are eligible for PUA. So this might be like our Lyft drivers, Uber drivers, DoorDash delivery folks. For those people, if they become unemployed or partially unemployed or unable or unavailable to work because of COVID, you have to also show that the pandemic has severely limited your ability to continue performing your work, and that as a result, you've had to suspend your work. So it's a little bit of a higher bar for gig workers to receive PUA, but I think that it won't be impossible for people to show that given the current situation. One thing I wanted to note was just about eligibility for unemployment for immigrant workers. So immigrant workers who are legally authorized to work in the United States can qualify for both regular unemployment and for PUA. Just like any other worker, for folks that have work authorization, your eligibility is going to depend kind of on your financial eligibility and the reasons for separation. It is the case that the UC agency will request documentation about your work authorization. So that's just one thing to keep in mind. Unfortunately, undocumented workers are ineligible for unemployment and PUA. So, this is a big concern for a lot of people that we at CLS help. And it just leaves a whole swath of workers, without benefits if they've been laid off or unable to work because of COVID. For people that do have work authorization, immigrant workers, one thing to note is that unemployment benefits, including PUA, are not included in the public charge analysis since they're not considered a form of cash assistance. So there shouldn't be any sort of negative impact on a worker, someone who has work authorization's ability to change status in the future. So I'm going to turn it over now to Seth to talk a little bit about wages owed upon termination.
Thanks. Just one thing to add about the last slide, which we don't have to go back to, but that DACA recipients and TPS recipients specifically they have work authorization, so they should qualify for unemployment compensation. I know that's a question that specifically comes up a lot. All right, so still in the area for people who have been laid off, right? And one thing, obviously, when a lot of businesses close and when they close suddenly, that we're worried about is that people are not being paid for their last weeks of work. And then often when that, if workers are now not working for that business anymore, they may be more likely to come forward with existing wage claims, right? For people who are not being paid overtime maybe, or not being paid what they were promised for many, many months before COVID hit. But now that they're no longer working for that employer and aren't worried about losing their job, they may be coming forward with wage claims. So one really important thing to keep in mind is that all the wage laws, state, federal, local wage laws, apply to everybody, regardless of immigration status. You have the right to be paid for the work that you've already performed, even if you were working without work authorization. And that's very, very clear. And so we help undocumented workers all the time file wage claims, go to court, and recover the wages that they should be paid. Technically, if somebody is terminate or quit, or if a business closes, the employer is supposed to issue the final paycheck within the regular scheduled pay period. Obviously, that may not be happening. And so we are, definitely seeing cases where people are coming forward because they haven't been paid their last few weeks of work. One other thing that is kind of related to wage claims is that the Philadelphia paid sick leave law, so I'll talk about that in the next slide in 1 second, what that means, because unfortunately I think there's a lot of people who don't know about it. But it's been interpreted that for any time that was accrued, and you have to accrue time under this law, but that you hadn't actually used before you were laid off, the city is interpreting that law to say that employers actually have to pay out that unused time. So say somebody had 35 hours of sick time they hadn't used and the business closed, you could file a complaint with the city if you haven't actually been paid out for those 35 hours of sick time. We'll go to the next one, Brianna. So just a little bit more detail about that law. So the requirement to actually pay workers for sick time only applies to employers that have 10 or more workers. All employers in Philadelphia have to provide sick time under the law now. It's to any workers who work at least 40 hours in a year, not in a week, but in a year in Philadelphia. Again, you accrue that time. So basically for every week of full-time work, you earn 1 hour of sick time. And you can use that time after you've been working for 90 days on the job. Again, that's for any worker, but if you work at a workplace that has 10 or more employees, that time also actually has to be paid at your normal salary. The city quickly passed some regulations that expanded the reasons that you can take sick time under the law to cover a lot of the COVID-19 related reasons, like if you don't have childcare and your kid's school closed, or if you have to quarantine because of COVID, or the workplace was shut down because of COVID, you should be able to use sick time under the Philadelphia law. The problem is that like I said, a lot of people don't know even about this law. Employers don't have mechanisms in place to actually track how many hours people had earned, even though they're required to do that. So people may not know how much they've used, although again, the maximum you can accrue under the law is 40 hours, period. So if you haven't used any sick time and you've been working there for a long time, you probably have 40 hours of time that you could use. And if you've been laid off, that should be paid out. And like I said, the city is accepting complaints with the Mayor's Office of Labor, which is the agency that enforces this law, to actually try to recover wages for people. So if people are owed wages for their last week of work, or they weren't paid overtime the whole time they were working there, or whatever it is, that's something that we definitely can help with. So our intake information there is on the screen. That 3700 number is our main line. So that's for all the different issues that CLS helps with. Right now we have an automated system that allows people to leave a message, and then hopefully we'll guide them to the right legal area, like housing or SSI or employment, and they can leave a message. The option 7 is for employment. I think you actually have to hit 1 or 2 first and then 7, but it's a system that hopefully people can navigate. It's a little complicated. We'll call them back. We can do an intake and talk about what they want to do. Generally, we'd probably start with sending a letter to the employer and then potentially filing a claim, depending on what the client would want to do. And we also can give advice for groups of workers or people who are thinking about trying to organize to address workplace safety concerns, or who have all not been paid, who are all laid off at the same time. And definitely feel free to reach out to us, to Rhiannon or me individually as well, if you have questions about referring workers. They also, like I mentioned, the Mayor's Office of Labor actually enforces both the sick leave law, as well as the city has a wage theft ordinance. I mentioned the local law about wage theft, and it's that same Mayor's Office of Labor They're actually a very responsive city agency now. They didn't used to be until like a year and a half or so ago, but now they're actually really great. They have investigators who can help people file claims on their own. It's a pretty simple process. They'll go ahead and contact the employer and try to recover wages for people, and they've been pretty successful. And they do not ask about immigration status, and they even will try to keep people's information as confidential as possible. So they are another really good resource, and their phone number is there, and you can also file online. I think we might share that in the chat. So one just quick distinction, we're going to talk a little bit about some of the sick leave, the federal paid sick leave that was passed as part of this package of federal bills. And so the FFCRA is one of them. Just really importantly, although Philadelphia's paid sick leave law has been interpreted to require employers to pay out unused time, the federal leave does not. It does not require that. So if somebody was laid off, the federal sick leave laws are not going to help people. It's only going to apply to people who are actually still employed. And now I think Rhiannon is going to talk a little bit about some of the stimulus payments.
So one thing we wanted to touch on, though not directly related to employment, were these economic impact payments, the one-time checks that people are getting from the IRS under the Federal CARES Act, just because we've had a lot of questions about it, and I expect maybe you guys have been getting questions as well. So under the Federal CARES Act, one thing that this did was create a one-time payment. It's called an economic impact payment to individuals. The payments are based on people's tax filings. So either their 2019 tax filings or 2018 tax filings. So folks who file their taxes and have an income up to $75,000 for individuals or $150,000 for married folks who are filing jointly are eligible for this payment. It's essentially up to $1,200 per adult. So if you're joint filers, it would be $24,000. And $500 for any dependents under the age of 17. One thing to note for young people is that you're not eligible for this payment if you can be claimed as a dependent by someone else. So, and also for people earning over $75,000, the amount that you receive will be decreased up to a certain amount, and then you're no longer eligible. It's about, I think if you earn over $100,000 or more, you're not going to be getting a payment. So one thing that we've been getting a lot of questions about is whether, this payment is a loan, whether there's any obligation to pay it back, whether people have to pay taxes on it, or whether it's going to affect next year's tax returns. The answer is that, simply put, this is just a one-time payment that's going into your pocket. It's not a loan. You don't have to pay it back. It's not going to affect next year's taxes, anything like that. So people were really concerned about, what they could do with this payment, but it's to help people out during this time and help stimulate the economy. So we just want to make it clear that, this isn't a loan and there's no obligation to pay it back to the government. So for people that haven't, so if you file taxes and you put in bank account information for direct deposit for like a past return, then you should get the payment via direct deposit to that bank account. For folks who don't have or didn't get money back when they filed their tax returns or haven't put in any bank account information previously to the IRS, the payment should be coming in the mail. For folks who haven't gotten the payment yet, you can check the status of the payment at irs.gov. And so you can see, if they've processed it, whether it's been sent out, whether it was sent out in the mail. For people that didn't file taxes in 2018 and haven't done so yet in 2019, they definitely want to go ahead and file their 2019 taxes so they get this payment. The deadline has been extended to July, so they should go ahead and do that as soon as possible. For people who are non-filers, So, they didn't have enough income to require them to file federal tax returns. They can also go to irs.gov and enter payment info online. For people who get SSDI or SSI or VA payments and haven't filed tax returns, the federal government should be using your information from those payments to give you this economic impact payment. So really the big concern here is for people who just didn't file taxes in 2018 and haven't done so yet in 2019 and are required to. They want to go ahead and do that as soon as possible to get the payment. One thing I did want to note is that unfortunately, this economic impact payment, you're only going to get it if you have filed with a social security number. So for a lot of our undocumented workers, they'll file tax returns using an ITIN, an individual tax identification number. For people who have filed federal tax returns with an ITIN, they're not going to be eligible for this economic impact payment. That also goes for people who, say someone filed their tax return using they have a valid social security number, but their spouse or their dependents do not have social security numbers. In those cases as well, you're not going to be eligible for the economic impact payment. So the government isn't only looking at the person filing, they're also looking at the family members. Essentially, everyone has to have a social security number to get this payment. Which again is going to leave out a pretty big chunk of people who could really use this benefit. And lastly, one thing I want to talk about in this kind of realm of folks who have been laid off is the issue of health insurance. So for people who have been laid off, our advice is to think about whether you're going to qualify for medical assistance or whether you should be going on to the ACA marketplace and trying to find some other health insurance. So for our clients, and I expect for many of the folks that CMAQ works with, many laid off workers are going to qualify for free medical assistance. Right now, we were talking about that extra $600 a week people are getting in unemployment benefits. That does not count towards the income calculation for medical assistance. So it's pretty big. If people earn too much to qualify for medical assistance, they're, like I mentioned, gonna wanna go on the marketplace. There is a 60-day window to act for people who need to buy insurance on the marketplace. So once you lose your job, you have 60 days to go on and apply. Once that 60 days passes, folks are going to have to wait till open enrollment to apply, which is in December. So, I think for people who were laid off around that week, maybe in March 16th, when the Pennsylvania shutdown order went into effect, that 60-day deadline is coming up very soon. So we just want to make sure that people are aware and thinking about this. Children may be eligible for medical assistance. For people who are low income, if you earn over a certain threshold, children might still be eligible for health insurance through CHIP. For folks who are applying for medical assistance, they're going to want to apply online through Compass, and the website is compass.state.pa.us. Or if they're looking on the marketplace for coverage, it's just www.healthcare.gov. So we at CLS don't really handle these health insurance issues, but if you have people who are looking for health insurance, aren't sure what they qualify for, or they need help applying, they can call FAN, and the number is there. It's 877-570-3642. And they can help them work through a lot of these issues.
Okay. So now we're kind of shifting gears into the second realm, right? So for people who are still working, but are concerned about issues relating to COVID. So we're going to talk a little bit about health and safety, which is something I think is coming up more and more for the people that we're seeing. Paid sick leave, again, mostly now focusing on the new federal law for people who are still working, as well as the federal law that covers taking leave for childcare. And then we talked about this a little bit, but I think we'll touch on it again, partial unemployment compensation. So health and safety, right? So everybody outside of COVID, before this, had a right and has a right to a healthy and safe workplace. And there's now, especially since the virus hit, there's been several different kind of guidelines put out by different agencies, most of which say basically the same thing. But there's things like, so one, like, should the business be open at all? Is it a life-sustaining business or an essential business? And while some businesses in other parts of the state have been allowed to open, Philadelphia is still, the shutdown order is extended till June 4th, I believe, right now. So businesses that are not essential or life-sustaining should not be open. And if you're working at one of those and you're worried about that, there's things you can do to try to get that shut down. There's also then, like, even if you are an essential business, is the employer taking precautions, right? Like if you work at a grocery store, are they just allowing everybody in at one time, or are they trying to limit the number of people in the store at once? Are they providing protective gear? Are they enforcing social distancing measures? There's things that employers should be doing. And then there's guidance, again, talking about the different standards for what's safe from the CDC and from OSHA, right? So the Occupational Safety and Health Administration. And again, state guidance on what protections should be in place for workers. Unfortunately, the thing that we'll talk about in a second is how to actually enforce these things. So just want to flag here that at least that the state has put out a complaint form that through the Department of Health that workers can use. Unfortunately, the governor recently remarked that they're just not going to be enforcing this order or complaints about it, and that workers should just not go to work if they don't feel safe, which is not helpful for a lot of people, I think. I think there's just a lack of resources. So there's an issue about like what the standards are, and then actually how to enforce those rights, right? So I talked a little bit about this, but things like, I didn't mention gloves and masks, cleaning with chemicals, right? So that's one that actually existed even before COVID, was working with dangerous chemicals. And now if you're being forced to clean your workplace a lot with dangerous chemicals, is that affecting your health as well? So these are just some of the concerns and some of the things that workers can demand from employers based on either the guidance or what I'm going to talk about in a second, which is kind of coming together to complain as a group of workers. So like I said, complaining to the Department of Health may be helpful, or calling 311 in Philadelphia may be helpful. Again, I think what we're seeing is that technically those are ways you can complain about your business being open or not taking sufficient safety measures. But is that actually resulting in enforcement and our businesses being shut down? I think what we're seeing is not really. Same thing, like complaining to, making an OSHA complaint. So you can file a complaint with the Department of Labor, the Federal Department of Labor, for OSHA violations, which could include not providing protective gear or doing these things to protect their workers. But historically, what we've seen, and I think probably more so now, given the limited resources, is that those complaints can take years to resolve and often are not very effective for workers. So what we're generally recommending is that workers organize, in a sense. So the National Labor Relations Act, the NLRA, which is generally, it's the law that protects unions and organizing unions in workplaces, also protects workers who organize in an informal way. So what's called protected concerted activity applies to any worker if they make a complaint about working conditions with one other coworker. So if a worker goes and complains about their working conditions and say they're fired because of that, and that could include things like safety in the workplace, they're not going to be protected from retaliation from being fired under this act, under the NLRA. They might be protected under OSHA, but again, if they make a complaint about that, might not be much that will actually happen for them. but they would not be protected under the NLRA if they only complain by themselves. But if they complain with at least one other coworker about their working conditions, they now have protection under this law, and they can file a complaint with the National Labor Relations Board, which has generally been way better about actually enforcing violations of the NLRA. So what we recommend is, again, putting things in writing is always a good idea, is joining together with at least one, if not several coworkers to complain about health and safety issues in the workplace. There's actually petitions that people can use. I'll put up some links in a second. Online petitions that help people kind of create letters. They could even use make a separate Gmail account or something like that to protect their own identity and kind of make a complaint as, like, you know, workers of X grocery store or something like that, to try to protect themselves against retaliation. But again, even if they are fired, they're then potentially protected from retaliation. And there's things they can do and make a legal claim that hopefully will be a lot more effective than other ones. Right, there's also, you can also make your demands public. That's protected under this law. And like I said before, if you're complaining about your workplace conditions and then are fired for that, you should be eligible for unemployment compensation. So at least it provides some kind of safety net. So this is a way that you can potentially both protect your job and also set yourself up for an unemployment compensation claim if things don't go well. One really important thing here to note, it's always a bit tough to give advice on this issue, is that they're technically, say if for undocumented workers, they have the same right against retaliation and to be able to organize. So this law covers them, and if they're fired, that is illegal under the law. The problem is that there are limited remedies under the law for people without work authorization. So basically, the main remedies we talk about for someone who's retaliated against is that they should be able to get their job back, reinstatement, plus back pay for any time that they would have been working had they not been fired. Unfortunately, those two main remedies are not available for undocumented workers if their immigration status comes out. The NLRB is generally good about trying to keep that separate. So it's just a little bit tough, but I always want to make clear before I go off and tell a bunch of immigrant workers to organize and make demands and say you'll be protected, that there's potentially some limitations that they should think about. So again, feel free to reach out to Rhiannon and me, or send workers to CLS. It's something that we do a lot of is trying to advise workers, help them think through whether they want to organize and what steps to take to protect their rights as best as possible. One really helpful thing is if there's like mixed status workers, if there's people with work authorization, without, and they're organizing together, that may help protect some of the undocumented workers in a way that if they did it on their own, they would not necessarily have the same protection.
So now I'm going to talk quickly about paid leave that's available for workers during COVID-19. This is a lot of information. I'm going to try and just give a brief overview. But under a recently passed law called the Federal Families First Coronavirus Response Act, or FFCRA, that law provides 2 weeks of fully or partially paid emergency sick leave for employers. It's going to cover essentially employees that work for a business that has 500 workers or less. So this, again, it's 2 weeks of, it's going to either be 100% of your pay or 2/3 of your pay, depending on the reason that you're taking leave for. And it applies for both full-time and part-time workers. If you're a part-time worker, it's going to be based on the average amount of hours that you work over a 2-week period. And it's up to 80 hours for everyone. So if someone works more than 80 hours in a 2-week period, you're only going to be able to get up to 80 hours of paid sick leave. And I'm going to talk in a second about the reasons for leave. But so there's that first bank of federal sick leave, which is 2 weeks. In addition, some folks might have paid sick leave under the Philadelphia ordinance that Seth had mentioned earlier. The Philly paid sick leave, again, there are some requirements for eligibility. You have to have worked in Philly for at least 40 hours a year. You have to accrue time, and you can only get up to 1 week. And it's going to be paid, or it can also be unpaid depending on the number of employees. So if your employer has 10 or more workers, Philly paid sick leave Philly leave will be paid. If there's 9 or fewer, that leave may be unpaid. And in addition, some employers have policies in place that provide for sick leave. So that could be another source of paid days for folks that need to take off for reasons related to coronavirus. One thing I wanted to note was that under the FFCRA, that federal law, that leave is in addition to the Philly sick leave and any additional days available under an employer policy. So in some cases, folks who are eligible for both FFCRA and Philly sick leave could have up to 3 weeks or more available in paid sick leave. Under the federal Families First Coronavirus Response Act, this also expanded the FMLA. So in this regard, for people who have to take off of work because they're caring for a child who is home because the schools are closed or because their care provider is closed, those people may be eligible for an additional 10 weeks of paid leave under this expansion to the Family Medical Leave Act. It's a little bit complicated. So it's essentially, it gives people 12 weeks for childcare. The first 2 weeks are unpaid, but people can use that 2 weeks of sick leave to get pay during that time. And then the next 10 weeks are going to be paid at 2/3 your regular rate. People familiar with the FMLA might know that there's a lot of kind of eligibility requirements for who can get FMLA leave. They've relaxed those requirements here. So essentially, you just have to have worked for the last 30 days for your employer to be eligible for this expansion. So what can this leave be used for? You can use leave under the Philly sick law or the FFCRA because you're unable to work because you're subject to a quarantine or an isolation order. So you can think of this about like the shutdown orders if you're unable to get to work because the buses are running on a reduced schedule, or you're under an order that you're not allowed to leave your house. Because a health provider has told you or a family member to self-quarantine. So we see this come up a lot for people who have underlying health conditions that put them at high risk if they're exposed to coronavirus. So if their doctor tells them that they should stay home and not go to work, they can use the paid sick leave for that reason. Also, if people are exhibiting symptoms of COVID and are trying to get a medical diagnosis, or like I said, if you're caring for a child whose school or care provider is closed due to coronavirus. So employers under the federal law can require certain info and documentation. This is essentially, they're gonna ask for some general information like the name of your healthcare provider, the name of the school that's been closed, things like that. And like I mentioned, the federal leave, it's either fully paid or partially paid. The easiest way to think about this is that if you're taking leave to care for yourself, the leave is going to be fully paid at your regular rate. If you're taking the leave to care for someone else, it's going to be paid at 2/3 your regular rate. So, if you're taking the 12 weeks to care for your child who's at home, you're only going to get paid at 2/3 of whatever your regular rate is for that 12-week period. One issue that we've seen come up a lot is employers telling people that they have to use all of their paid time off before they can use this federal leave. That is not the case. It's not true. Under the federal Families First Coronavirus Response Act, employers are prohibited from requiring the use of any existing PTO before the emergency sick leave or the expanded family and medical leave. So this federal leave should be available for you to use right away. And you don't have to use any of kind of your vacation days or anything like that before you're able to use the federal leave. As a more general matter, we've been getting a lot of questions about whether employers can force people to use all of their PTO against their will. So, can my employer make me, I have 10 vacation days and our business is being shut down and my employer wants me to use all of my 10 vacation days during this closure. Generally, workers, that's not permitted, but it really is going to turn on whatever policies and practices the employer has in place. So if you run into clients with these issues, it's definitely something that you can refer to us at CLS, and we can help people think through and address these types of issues with their employer. And one final thing, I mentioned this earlier, but I just want to reiterate that workers don't have to exhaust their existing PTO before applying for regular unemployment benefits. So, again, if you apply and get unemployment benefits, you're going to be doing that bi-weekly certification to report any income. So if you're receiving any PTO during that time, you would just report that in your bi-weekly certifications. A bit different is PUA. So if you're getting PTO, you're not going to be eligible for PUA while you're receiving PTO. So that's just one slight difference to note. And just quickly, for people, I mentioned this before, but it does fall into this category of people that are still working. If your hours have been reduced, you can still apply for partial unemployment or PUA. And to make up some of your earnings for the hours that you've lost because of coronavirus. And even if your hours have been reduced, if you're only working part-time, I mentioned this earlier, but you're still going to be eligible, even if you're working part-time, for that emergency sick leave under the Federal Families First Coronavirus Response Act. And lastly, we've seen this coming up more and more often, are just issues for people who are being asked to return to work right now. And, this is especially on people's minds that are now receiving unemployment or PUA and getting that additional $600 per week in benefits. People are wondering, with the health and safety issues, if they have to go back to work. A lot of people have childcare issues or just are concerned because they're being offered less in wages at their job than they're currently getting in unemployment benefits. As a general matter, if someone's receiving unemployment benefits and they receive an offer to return to work, generally, if you refuse the offer without good cause, you may become ineligible you might lose your unemployment benefits. So when you're thinking about whether someone has good cause to refuse an offer to return to work, good cause might be if you have an underlying health condition that puts you or a family member at high risk. If the worksite isn't following that guidance that we talked about earlier from the state or the federal government about health and safety in the workplace, or if you lack childcare and you're unable to return to work for that reason. All of those may be good cause to refuse an offer to return to work, but there's always a risk of losing benefits or being assessed an overpayment. So one thing, we really want to flag for people that are in this position is to always raise these issues with your employer before refusing an offer to return. If possible, you again want to raise them in writing so you have some sort of evidence. And ultimately, if you refuse to return to work and your employer contests your eligibility for benefits, it's going to be a case-by-case determination by the UC agency, depending on the specific facts of your case, whether you're going to remain eligible for benefits. And of course, we're here if people have questions about this to help them think through these issues and, maybe even raise health and safety concerns or other health concerns with their employer. So, you can always refer people to CLS. This is the kind of thing that we'll help people with. And lastly, I just want to make you guys aware, this was a lot of information to cover, but we have updated info on our website. We have a specific page with information related to coronavirus, not only about, workers' rights during this crisis, but also as you can see here, a variety of other topics as well. So you can always refer people to our website if they need more information, or if you just need a refresher. Our flyers and FAQ, things like that are all available on our website. So now I'm going to turn off the recording and open it up so we can take questions.
I think there's a question.